Welcome and thank you for standing by. At this time, all participants are in a listen-only mode. To ask a question during the question and answer session, please press *1 on your touch-tone phone. Today's conference is being recorded. If you have any objections, you may disconnect at this time. Now I will turn the call over to Ms. Janice Winko with International Trade Administration. Ma'am, you may begin.
Thank you. Welcome to today's webinar. Today we're very pleased to have a very distinguished scholar and practicing lawyer in Canada, Sean Zhang. Sean is with the firm of Blakes, and he will be talking to us today about proposed Internet regulations that have been proposed by MIT. Comments for these regulations are due on February 14th if people in industry are interested in submitting comments to the Chinese government. Before I turn it over to Sean, let me tell you a little bit about him. He's quite impressive. He has a PhD in physics from Caltech, and that was after he received his undergraduate degree in sciences from Zhejiang University. He's worked as a researcher in the United States, Italy, and in Canada, as well as a software engineer prior to practicing law. And right now he is a member of the Canadian Advisory Committee on drafting and reviewing international standards for the information technology industry. He's fluent in Chinese as he's fluent in English, and he has quite an extensive practice with his firm Blakes in Toronto. Sean, I'm going to turn it over to you, but please note that after the presentation, Sean has been very kind to say that he would be willing to answer questions from presenters. You can call in with *1 to the operator, or you can use your drop-down box, the Q&A box, to write in questions to Sean. Sean?
Thank you, Janice. First, before I start, I'd really like to thank Janice Winger for inviting me to give the talk here. And also thank you, everyone, for participating in this webinar. Recently, China proposed some new Internet regulations that's directed at regulating the activities of Internet information service providers. The new regulations are aimed at establishing a more regulated Internet information service market. So this talk is going to provide a brief introduction to the proposed regulations. Here's an outline of today's presentation. First, I will give a general overview. The proposed regulations deal with two aspects of regulated market order, unfair competition, and also consumer and privacy protection. So I will spend some time on each of these. I will also speak very briefly about dispute resolution and remedies available under the proposed regulations, and then finish the talk with some concluding remarks. The title of the proposed regulations is Provisional Measures for the Supervision and Administration of Market Order of Internet Information Services. It is a draft at this time. The draft was prepared by China's Ministry of Industry and Information Technology, or MIIT. The entire text of the draft can be found at MIIT's website. Email address and the fax number are also provided there for receiving comments from public. The consultation period is 1 month. So the consultation will end on February 14th, as Janice just mentioned. We have 5 more days to provide comments. The proposed regulations, they are made under 2 regulations administered by MIIT. These 2 are telecommunications regulations and Internet Information Service Administration measures. As you know, different ministries in China have different mandates. Typically, maintaining market order is the responsibility of China's Ministry of Commerce, or more particularly the State Administration of Industry and Commerce. In this case, it relates to Internet or the market order of Internet information services. So this is treated as part of telecommunications industries in China. So MIIT is the ministry responsible in this case. The provisional measures will apply to Internet information service providers, or IISP. IISP itself is not defined in the draft, but Internet information service is defined in the Internet Information Service Administration measures. It is defined as a service to provide information to Internet users through Internet. So here, the IISPs could be information content service provider or information product service provider. The proposed regulations could have the potential of reaching companies providing information or even software products in China over Internet. So suppose you have a business operation in China or work with a Chinese partner in China in this area, or even if you only invest in a company in China operating in this area, you could be potentially affected by the regulations when the regulations are finalized and come into force. The proposed regulations are divided into 5 chapters. It has 27 articles in total. Some of these are fairly general and broad in scope. They essentially simply repeat some general principles that can also be found in other laws but are applicable when it comes to providing information services over Internet. Some other provisions can be fairly specific and detailed. Indeed, some of these, as you will see, essentially impose very specific restrictions on what cannot be done and what must be done under certain specified circumstances. So next we'll be spending some time looking at provisions dealing with unfair competition and also consumer and privacy protection. First, unfair competition. The general principle is that IISPs should compete fairly and orderly, not to disrupt the market order. The draft regulations list 5 categories of activities as unfair competition. So there could be unfair competition if a company did anything in one of these categories. The first category deals with what one cannot say about competitors' products and services. This is really not surprising, as it merely repeats some of the general principles. Essentially, you cannot say anything that is not true, or even worse, you cannot fabricate any malicious lies about your competitors' products and services in order to injure their commercial reputation. The next 3 categories deal with incompatibility issues, mostly about what to do or not to do when a company's products or services are not compatible with its competitors' products and services, or would become incompatible. The fifth category is a catch-all category, which is not listed here. So let us first look at the compatibility issue. As the IISP, under the draft regulations, it will need to observe what I call two rules, the no introduction rule and the no interference rule. First, a company cannot introduce any incompatibility unless, of course, it has a good reason. According to the draft regulation, without any justifiable reasons, one cannot render others' legitimate products or services incompatible. From the language of this draft, it is not clear what could be some acceptable justifications for allowing any incompatibility. For example, can the justification be for some commercial reason? One simply cannot afford to make it compatible with all other products and services out there, or simply when someone, when we upgrade or modify the products, we simply overlook something. It is not clear. We may have to wait when further guidelines come out or new cases come out. So at that time, we could get a better idea. Next rule is what I would call the no interference rule. The IISP cannot interfere with the operations of its competitors' products and services. It also cannot modify the contents of its competitors' products or services, and also it cannot intercept information of its competitors' products and services. Again, here it is not clear what would constitute interference. For example, does it mean rendering others' products and services no longer compatible to the extent of being mutually exclusive, or does it mean merely causing some occasional difficulties when running competitors' products? Likely, if a competitor's product is prevented from starting up, it would be treated as interfering. But just how broadly interference could be interpreted is not clear. And if you also look at this provision, it could be viewed as some kind of explanation of what is incompatible. But also, this also may be viewed as a stand-alone rule. I would treat this as a stand-alone rule because it also includes some other activities, such as intercepting information of competitors' products or services. So that's when that's about what you cannot do when there's a possibility you may introduce some incompatibility. Now, what if there's already incompatibility? This could happen due to some other factors. In particular, here it says that if it's for the reasons of, it's not for reasons of intentional human intervention. When that happens, the Internet Information Service provider will have to deal it fairly in that it would have to let users to make an informed decision or choice. To ensure that this will happen, the drafted regulations impose an obligation of objective notification and also require respecting users' rights to choose. So to people familiar with consumer rights protection law, these rights to know and the rights to choose should not be a surprise. Therefore, there would be an unfair competition if an ISP did not inform the user in an objective manner of the existing incompatibility, or deceive or induce users to make a choice, for example, to use its own products over the competitive products. A company also would be found to have competed unfairly if it simply misled or forced a user to install or stop using its competitors' products and services. Evaluation reports. As mentioned earlier, statements about competitors' products and services cannot be false. One also cannot fabricate malicious lies to injure competitive commercial reputations. But what if you say something that would be true about your competitor's products or services? These draft regulations would put some limits on what one can say. There would be, for example, some certain statement a company cannot make about its competitor's product services if it would not want to be found to have competed fairly. These statements would fall within 3 areas. That is security, privacy protection, or quality of competitors' products and services. Suppose you suspect a problem in any of these 3 areas. You would not be prevented from evaluating your competitor's products or services. You can also generate some evaluation reports if you keep the report internal. The only thing you cannot do is to publish it. Instead, what you must do is to submit the disputes to a third-party authority for evaluation. Presumably, once you have obtained a report from the third-party authority, then you can repeat what is said in the authority's evaluation report. So at that time, you would be able to fulfill your duty to notify your users of any such problems. The draft regulations do not say who are such third-party authorities or how one can know. Only that new rules or regulations will be made for establishing or designating such third-party authorities. So before then, you cannot say anything about your competitors' products or services in any of these 3 areas. So let's hope that the new rules or regulations about establishing or designating such authorities will come into force the same day at least as these provisional measures are finalized and come into force. So to summarize, the ISP must compete fairly, and under the draft regulations, 5 categories of behaviors will be treated as unfair competition. 3 of them deal with incompatibility, or what you can say or cannot say, or what you can do, you cannot do in this area. And also, when you suspect some quality, security, or privacy issues with your competitors' products or services, you cannot publish your own evaluation report. Instead, you would have to ask a third-party authority to make the evaluation. So that's for unfair competition. Next, consumer and privacy protection. In addition to unfair competition, the draft regulations also include some new rules on user protection and privacy protection. This part of the proposed regulations includes 6 articles covering from, for example, installing or removing software on users' equipment to pop-up windows. So let's look at these in some detail. Software on user terminals. There are several new rules that are proposed on what one must do or cannot do when install software or modify software at users' terminals. The first rule is no automatic installation or modification. There must be clear notification and user agreement. Before these 2 requirements are met, no software can be installed to users' terminals or equipment, and no modification can be made. These same requirements, that is a clear notification and user agreement, also would apply to uninstall, upgrade user software, and even to execution of user software. Presumably, when you run any software on user's terminal, you will need to get user agreement only once, not every time you run it. But this is not explicitly stated in the proposed regulation. The proposed regulations also have a rule specifically directed at tied installation. As one way of generating more revenue, a service provider often installs other software when it upgrades or installs its software used for its services. This itself is not forbidden. But before you can install other software, you would be required to get user agreement as well, and also let your user decide whether to install. Automatic tied installation will not be permitted. As I mentioned earlier, some of the rules are very specific and detailed. Here is one example. One would be specifically prohibited from modifying users' browser settings to force users to visit any particular URL. Of course, if you get user consent, then that's okay. So that's for installation and modification. And the next, the draft regulations also have some rules on uninstallation. If you install some software on the user's terminal, then you would have to provide an uninstall option. In addition, the uninstall you provided also must remove everything that you have installed. You cannot leave anything behind, unless, of course, it's not your fault. As I mentioned earlier, it is okay to install other software in a tied installation, that is, software not directly related to providing your own services. However, if you have installed other software as additional software in a tied installation, then you would have to provide a separate uninstall option so that a user would be able to remove only the additional software if he or she so chooses, and would not have to uninstall everything together. Pop-up windows. The draft regulations also will impose some new rules on how to handle pop-up windows. First, a user must be able to close your pop-up window, and the means provided by you to close the pop-up window must be clearly labeled. Second, if a pop-up window is already closed by a user, you cannot pop it up again with the same or identical content unless you have a good reason. Otherwise, you would have infringed the user's rights based on which the user could file a complaint against you. So that's for consumer protection. Again, as you would expect, 6 articles cannot be comprehensive. So at best, they would only deal with some of the perhaps more pressing issues. These provisions actually appear to be prompted by the 3Q disputes and tailored to some of the actions taken by the parties in that dispute. Privacy and personal information protection. The proposed measures also contain a few new rules on privacy protection. Again, with only a couple of new articles or new rules, these cannot be anything close to comprehensive privacy protection legislation or regulations. For example, although it talks about the protection of personal information, the term personal information itself is not defined. The only thing we know are from the examples provided in the draft regulations that personal information could include user identity and also user behavior. Under the draft regulations, several requirements must be met before the IISP can collect and process personal information. The requirements are listed here. First, the personal information collected must be directly related to the services provided. Second, you must notify the user of the personal information to be collected, why you are collecting it, and how it will be used. And third, the collecting of personal information cannot go beyond the scope of a service provided. And of course, user consent is always required. In this case, the drafters went one step further. The user consent must be explicit user consent. Suppose now you have all these personal information in your hands. What can you do? The draft regulations specify some additional rules in relation to this collected personal information. The disclosure to third party of any personal information, or the inspection of content of any user information in your hands will be prohibited. The language used in the draft regulations is rather strong in this case. For example, you cannot disclose personal information to a third party for any reason. The only exception is when such disclosure would be otherwise provided for under law or regulation. But as I mentioned earlier, there is no definition of personal information. So there is also no, and also there is no mention of aggregated information. So it is not clear from the language of the draft regulation how broadly this provision would apply. For example, would this apply to only personally identifiable information? That is, information from which you can identify the person, or would that also include aggregated information processed from personally identifiable information? Or would this apply to personal information that could lead to identification of the person if combined with other personal information? How strictly should we interpret this provision? It's not clear. I think we'll have to wait for more guidelines from the ministry when regulations come into force. Similarly, user information is also not defined in the draft regulation. So it is not clear what would constitute user information and what would be treated as inspecting the contents of the user information. So some of the problems with draft regulations is that there is a lack of a clear definition. This would mean that complying with these regulations or these new rules, in particular, for example, here these two provisions could be difficult. So it might be worthwhile to watch very closely how these provisions would be interpreted and enforced, or what the finalized version will be. Hopefully the finalized version would be more clear and provide us with some better guidance. Here are some more rules dealing with the protection of user data and user information. One rule I'd like to highlight here is what to do when there is a data breach of personal information. The IISP in this case has a positive duty to report the data breach to the relevant government authorities immediately. In addition, you cannot publish any unverified information without authorization. So additional requirements would have to be met before you can inform your users of any data breach. But how can you verify the data breach? You probably can suspect some data that has leaked, but to verify that, maybe you can do that when you catch the hacker. In any case, according to the draft regulations here, the reporting duty you owe under the draft regulations would be to the authority, not the users. But this may create some problems when you have requirements under the regulations in other jurisdictions. Under the proposed regulations, user would have more control over its own data, in particular its self-generated user data. This self-generated user data could include text, pictures, audio or video content. So they might be, for example, email messages, postings, uploaded pictures, etc. IISPs, on the other hand, would have more restrictions in how it can handle user data. Now I'm going to speak very briefly about dispute resolution. The proposed regulations encourage industry self-regulation. So if there's any dispute between ISPs, it would be for the disputing parties to resolve the disputes through mediation by trade or industry organizations. In the event the dispute could have a serious social impact, then the national or provincial authorities may get involved and also direct, coordinate, or mediate the resolution of any disputes. Once a resolution agreement is reached, the parties must implement the resolution within certain time period that is to be stipulated in the agreement. There would also be some reporting obligations under the proposed regulations, which I will not get into detail here. But I will mention that these reporting applications would arise only when the disputes would be such that the action of the parties could jeopardize security measures that are put in place. Remedies. In addition to disputes between ISPs, a user's rights could be affected, and a user can file a complaint with the relevant regulatory bodies for any breach. Government authorities can also launch their own investigation. If there is a finding of unfair competition or failure to protect users' information or privacy, then there could be fines imposed. The fines can be up to 1 million yuan. If users have suffered any damages as a result of the breach, compensation to users also could be possible. Also available under the draft regulations would be what we often see in Chinese regulations, that is an apology and also a suspension of business operation. I should emphasize here that to an Internet information service provider, we should never underestimate the power of suspending business operations. First, the revenue loss suffered during each day of suspension probably can easily exceed the fines imposed. Second, the competition in this area is often very fierce. Customer loyalty may not be that strong, so users could easily move to other service providers during the suspension and never come back. So the consequence of having business operations suspended could be very severe. Sorry. Just try to get back.
Hello?
Yes, looks like I'm having some trouble getting back to. Okay, there it is. This will be the last slide. Just to summarize, the proposed regulations enumerate 5 categories of behavior as unfair competition. These will be regulated. These mostly relate to how to handle compatibility and also what to say about your competitors' products and services. The rules also attempt to provide some more user and privacy protection. So in general, this should be viewed as a positive steps. But some of the key terms are not defined. A few provisions that could lead to serious consequences for the business also are not very clear as to its boundary. Again, we all have seen that there are some very specific provisions, and also there are some very general provisions stating basically general principle. The gap exists between the general principles stated in the draft regulation and also some specific, very detailed rules. So for the company to be able to comply with these new rules, it could be difficult and problematic. So it is worthwhile that we keep a close eye on these rules, on how they would be implemented and enforced in order to avoid being a subject of controversy under any of these proposed rules. But right now, this is still a draft, and the draft is under public consultation. So we don't know as yet what comments have been received, but we should expect that changes to be made when MIIT will release the final version. Of course, if you feel strongly about any of the provisions or have some suggestions, as I mentioned, the consultation will end on February 14th, so you can also submit your own comments. So I think that's it. I will stop here. If you have any questions, I will try to answer them now, or you can also send me an email message so we can discuss this offline. Thank you.
Thank you, Sean. The operator will tell us now how you can dial in and ask a question.
Thank you. If you'd like to ask a question, please press *1. To withdraw your request, *2. Once again, to ask a question, please press *1. One moment, please.
Also, if you would like to know where the MIT measures are on the website, if you look in the Q&A box on the top, there's a drop-down window. I've listed the web page where they are in Chinese. If not, please send me an email and I can shoot you the link.
Once again, to ask a question, please press *1. There are no questions at this time.
Sean, before we let you go, I do know I'm going to check to see some people may have somebody had actually asked an email question, but then he later said that you had actually answered it in your presentation. So I want to thank you for that. But we would like to thank Dr. Zhang, who's a lawyer in Toronto. If you have any questions, he said he was very, very happy to speak with you. As you can see, both his email and his phone number are there. This webinar will be posted on our stopfakes.gov website. And in case there's any additional questions that come in, I just wanted to have a plug for the next webinar, which will be on February 17th at the same time, 2 p.m. This one is on China's Indigenous Innovation Policy. So the announcement for that just went out 2 p.m. on February 17th, 2 p.m. Eastern Time. Well, if there are no other questions, I'd like to thank Dr. Zhang again for a very detailed presentation. I'm sure that some members of industry will be commenting. And again, we thank you for giving us your insights in this. And we'll talk to you all at the next webinar on February 17th.
Okay. Thank you, everyone. Thank you, Janice.
Welcome.
Thank you for participating in today's conference call. You may disconnect at this time.